Good morning. Welcome to the Hall of Justice on our second day of our October call. Our first case is Attorney General versus Eli Lilly. This is a 15-minute mini oral argument on the application, but I also have 5 minutes for Mr. Novak. Is that correct? Okay, great. You have 2 minutes of a free fire zone, which you may waive, and we ask that if you would like to reserve time for rebuttal, that you keep track of that time, and I will do my best to remind you when we get close to that. And you may proceed when you're ready.
May it please the Court, Assistant Attorney General Darren Fowler on behalf of Plaintiff Attorney General Dana Nessel. Attorney General Nessel is here at council table today because seeing the Michigan Consumer Protection Act restored to its original integrity is of great importance to her and the people of the state of Michigan. I would like to reserve 2 minutes of my time for rebuttal. In 1976, the legislature provided an enlarged remedy for consumers who are deceived or exploited in the purchase of goods and services for personal, household, and family purposes. But because of the Smith and List decisions, this act cannot be applied as originally intended. The present dynamic allows a seller to get out from under it if they can merely point to some general authorization or a license. The present dynamic would bewilder any Michigan consumer who finds that they cannot rely upon the Consumer Protection Act when they have rain dripping on their head because a roofing contractor has lied to them, when they can't get to their job in the morning because a dealership has sold them a clunker, when they can't pay their electric bill because the local grocery store is price gouging on milk, eggs, or formula, or, as in this case, when they have to ration or even forego life-saving medications because they cannot afford them. Smith and List were wrongly decided. The Act's narrow exemption was transformed into a gaping hole, and the test in these decisions was moved from being one looking at a transaction or conduct that is specifically authorized to merely looking for some general authorization under a regulatory scheme. There are 2 aspects of the presentation from Lilly and its supporting amici that warrant response. First, Attorney General Nessel absolutely agrees with the statement made by the Michigan Chamber of Commerce when it says, quote, "Consumer protection is critical to a well-functioning consumer economy," end quote. To that, we add that consumer protection is essential to a well-functioning business economy. Consumers who are tricked into spending their hard-earned money with unscrupulous builders, dealerships, and other sellers lose the opportunity to spend those dollars with the honest businesses in their communities. And consumers who are price gouged then struggle to pay other bills to legitimate companies like the utilities, the mortgage lenders, and the insurance companies. Deception and price gouging hurt everybody. Second, Lilly and amici tried to obscure the extent to which the Smith and List decisions make Michigan an outlier nationally in how its Consumer Protection Act safe harbor provision is interpreted. Help comes to us there from General Motors in their amicus brief, where they cite the Chapman case, a class action being heard by Judge Berg in the Eastern District of Michigan. That case involved a private class action invoking claims under the consumer protection statutes of 49 different states plus the District of Columbia. General Motors brought a motion to dismiss, and in resolving those motions, the only state consumer protection law that was dismissed for the safe harbor reasons that Lilly is invoking in the context of this case was under Michigan's law. There were a handful of other states that, yes, were dismissed from that case for other reasons, like there was no class action provision within that consumer law, or there was no damages remedy for private claimants in that case. But at the end of the day, the claims under 36 state consumer protection laws plus the District of Columbia were left standing, surviving that motion to dismiss. So if you want to see
Mr. Fowler, can you help me with, even if we were to agree with you that Smith and List were incorrectly decided. What do we do with the fact that for 25 years, everybody in Michigan has been relying on them? I mean, stare decisis principles sometimes say that even a wrong decision that is deeply embedded and strongly relied upon should remain. What's your argument against the strong reliance interests?
There's really two different reliance interests that are invoked. That which Lilly is trying to point to, hey, businesses have just been used to these cases having existed, as you articulated, for 20, 25 years. But the answer to that is this is a statute, the Consumer Protection Law, that says to companies, don't lie to Michigan consumers when you sell things to them. Don't price gouge them. Don't take advantage of disabled buyers. These are basic, baseline types of requirements that every business should already be doing. Any business that has relied upon the absence of the Consumer Protection Act in Michigan being applied to them to help continue a business model of lying and gouging and deceiving is not a company that should be allowed to continue in that. There's no recognized reliance interest forming from that. But the other more important reliance interest that comes into play under the practical workability prong of the stare decisis analysis is what the consumers rely upon in the law. Practical workability, of course, has the three prongs, and the most important prong of that is consumers. As people reading the statute, what are they going to expect it is going to provide? Section 1 of the Consumer Protection Act says this act shall be known as the Consumer Protection Act. A consumer who reads that act is going to think, yes, this is an act that is going to protect me as a consumer. But
is transaction broader than conduct?
A transaction absolutely can be broader than conduct. There are subcomponents of conduct in a transaction, but conduct can also be broader than transaction. There is always conduct that precedes any transaction as a company is marketing its product. There is often conduct that comes after a transaction, like where a company may try to deceive a consumer about the consumer's legal rights even after the transaction is completed. So in different ways, each can be broader than the other, but the important statutory analysis is they are given equal dignity under the statute. And really, that goes to one of 2 points under the Smith decision that I think warrant highlighting. One, the court, in doing that analysis, got very caught up on the idea of conduct and what does it mean within the context of the statute. And that they were really grappling with that, we can see after that block quote from the Diamond Mortgage opinion, which is still good law, where the court completely misstates what the statute requires and says, quote, in short, Diamond Mortgage instructs that the focus is on whether the transaction at issue and not the alleged misconduct is specifically authorized. Of course, end quote. Of course, the statute tells us that transaction or conduct should be considered whether each is specifically authorized, given equal dignity.
Counsel, if we accept your interpretation of the statute, which, as I understand it, is that every aspect of a transaction has to be approved by a regulatory authority, including all the terms of the transaction, including one of the most important ones, the price term. What would the exemption apply to going forward?
Justice Viviano, I have to disagree with the premise there. Our argument is not that every aspect of a transaction has to be articulated in the regulatory scheme. The argument is that the appropriate focus in each individual case is the specific aspect that is being alleged as unlawful. So when we talk about Eli Lilly, we're not alleging that Eli Lilly is wrong to sell insulin writ large. The allegation is that Eli Lilly is charging a grossly excessive price by charging, for example, $570 for a pack of 10 Quick Pens. So the scrutiny in any given case should be given and applied whether the conduct or transaction at issue in that individual case is specifically authorized. So, while there obviously are other components to any transaction, like a pharmaceutical purchase, we're not scrutinizing the extent to which other unrelated regulations are implicated.
Counsel, I'm wondering, just getting back to Justice Kavanaugh's question and stare decisis. So Smith and Liss, I know, obviously, took a detour from Diamond Mortgage under your argument. They did not do a stare decisis analysis. How does that factor into our decision with what do we do with Smith and Liss?
Obviously, for courts applying the Michigan Consumer Protection Act, that is problematic. Right now, we have really competing valid precedents. Smith and Liss did not invoke the doctrine. They engaged in kind of a fiction that Diamond Mortgage was in accord with them. Under the practical workability analysis, I think that factors in because it is a source of confusion as to the appropriate law. And the prosecutors, in their brief supporting the Attorney General, I think make a very good illustration of different cases where that confusion comes to fruition. I'd point this court, for example, to the Santa Fe case in the prosecutor's brief, where the district judge there says, I'm paraphrasing, but essentially, the Supreme Court of Michigan has not given clear guidance on its safe harbor provision. There's also a district court case there involving Oppenheim versus Volkswagen that comes to a conclusion that really cannot be squared with the Michigan Court of Appeals holding in Sear versus Ford Motor Company. There is confusion created out there by this two different strains of precedent, and the best course is for this court to restore the Act's original intent as passed by the legislature, what the consumers would expect of that Act. They expect it is going to help them in the purchase of the necessities of life, like cars and home improvements and home construction and groceries. And
Counsel, let's go back to your answer to my question. I've been sort of pondering it, trying to wrap my mind around it. And all I can come up with is that you do not believe that the statute exempts a transaction unless the entire transaction and every bit of it is approved by a regulatory authority. Is that a correct?
No, respectfully, Justice Viviano. In our brief,
you want the exemption to only apply to elements of a transaction. And I'm trying to figure out when it says the Act doesn't apply to either of the following, a transaction. It seems to me you've written that word right out of the statute.
we recognize with the example that we include in our briefing related to MSHDA's approval of consumer-specific lease transactions, that the fact that MSHDA approves a particular lease between John Smith and the landlord, there is no way for John Smith to use the Consumer Protection Act to attack any aspect of that transaction, regardless of whether MSHDA...
So only if a regulatory body approves every element of a specific transaction involving two parties, then that transaction is exempt. That's your position?
No, I would say that it is when a transaction is specifically authorized by an agency, then no aspect of that transaction, whether considered by the agency or not, can be used to overturn that transaction under the Consumer Protection Act.
Wait, can you say that again?
Yes. When a government agency specifically authorizes a specific consumer transaction, no aspect of that transaction can be attacked under the Consumer Protection Act, regardless of whether that aspect was considered by the agency or not.
So I think we're saying the same thing. The regulatory body has to approve a specific transaction, including all of its constituent parts, between a specific two identifiable parties. In that instance, that's the only instance in which you believe that the transaction itself, as opposed to parts of the transaction, would be exempt. Is that right?
I disagree again with the articulation, Justice Viviano, but I think I don't think that we're going to see eye to eye on that particular.
Well,
Mr. Fowler, you have 1 minute left.
That may be so. I'm just curious which part of it you disagree with, unless I'm not comprehending.
The transaction When the MSHDA reviews a transaction, it may not review every component. It may not review, for example, whether there was the landlord lying to the tenant about the quality of the furniture in the apartment, but the act still could not be applied because MSHDA approved the transaction.
Okay.
Thank you.
Good morning, Justices. Paul Novak on behalf of the Michigan Association for Justice. I have simply 4 quick points I'd like to present to the court. I have to confess I am coming here in part as my capacity of the ghosts of attorneys general past. I engaged in and had the privilege to do pharmaceutical pricing litigation for attorneys general Kelly, Granholm, and Cox. And a number, which leads to my first point, a number of the historical pharmaceutical pricing cases brought by the Attorney General would not have been successful with the articulation of the specific authorized interpretation that Lilly is presenting to this court today. Let me give an example. Lorazepam, anti-anxiety medication. The manufacturer of that medication entered into an exclusive supply arrangement with an Italian company. As a result, increased the price 2,000% in the United States. The Attorney General at that time brought an action under the same grossly excessive pricing provision that's at issue today, also under an illegal monopolization claim. The Federal Trade Commission and roughly 30 other states also sued, and that action was successful, led to a $100 million settlement. Another case, Cardizem CD, branded pharmaceutical manufacturer pays a generic manufacturer $80 million to stay off the market. That case was an antitrust case, but the same or almost identical special authorized or specific authorized transaction provision existed in the antitrust statute. Similar situation. They maintained the high branded price of the drug by paying the generic to stay off the market. Some other cases, the Buspar and Taxol cases, involved instances where drugs, where the manufacturers inappropriately and fraudulently used patents to prevent the generics from coming to market and maintain high prices. All of those cases were ones brought by the Attorney General in times past. All of them involved drugs where the FDA had approved the safety and efficacy of a drug. But to say that when the FDA approves safety and efficacy, it means that they approve things like illegal price fixing between competitors, or paying a generic to stay off the market, or monopolizing a drug because you've engaged in an exclusive supply arrangement, that extends the scope of the FDA's approval far beyond what I think was intended. And as a result, only when you characterize this general transaction as being specifically authorized in the manner that Smith and List did, do you get to a situation where somehow all of that type of illegal conduct is exempted, which was never intended, and which I think Diamond Mortgage correctly addresses in its formulation of
So
the
counsel, are
specific
you
authorization.
dividing out transaction, like transaction is more, it's obvious, your argument is it's more than just the big, single act of selling the drug, but instead it's, I'm trying to get to Justice Viviano's concerns. How do we parse out the start and end of the transaction?
The question becomes, what is alleged to be unlawful under the Consumer Protection Act? And if it is some component of the transaction or conduct, it doesn't matter which, but what's alleged to be unlawful, and was what is alleged to be unlawful Has that been specifically authorized?
Right, and I know your brief sort of gave an example where perhaps if pricing was wrapped up into the federal regulation.
Well, the filed rate doctrine recognizes, for example, that when a PSC, for example, authorizes a specific rate to be charged for electricity, then that has been specifically authorized. I can't come in and challenge that rate as being grossly excessive. It's been specifically authorized.
It sounds to me like your position conflicts with the current Attorney General's position. Am I wrong?
I think the position that I'm advocating is consistent with what the Attorney General is advocating, if that's your question.
What I just heard from counsel was that if a specific transaction is approved, but the approval has nothing to do with pricing, then the exemption would apply. But you just said we shouldn't think of approvals that way. If they don't, if the approval didn't pertain to pricing, then an enforcement action on pricing should be allowed to go forward, unless I misunderstood your position.
Correct. If the governmental entity has not approved pricing, and pricing is the conduct or is a part of the transaction that the Attorney General or any litigant contends is grossly excessive, then that would not have been specifically authorized.
So I take your position to be even more narrow. So what's left of the word transaction in the statute if we accept your interpretation?
Those components of a transaction that have been specifically authorized are exempt from the Consumer Protection Act.
So this means the same thing as conduct. Do you think the two words should be interpreted to have the same meaning?
No, not at all. There are components and transactions that are entirely different than conduct. I'll give an example. Footnote 5 of our brief talks about the marketing of a pharmaceutical where Department of Justice ended up bringing criminal charges against the manufacturer because they, in their sales and marketing of that product, engaged in criminal or what Department of Justice contended was criminal characterizations of what the drug could do. It was an opioid product that they marketed as being addiction deterrent and crush resistance, when the FDA specifically did not allow them to include those characterizations in its label. Now, under Lilly's interpretation, that criminal conduct was specifically authorized, which is absurd. Justice Kelly, in her dissenting opinion in the List case, identifies, look, one of the problems with this characterization is that illegal conduct is now characterized as being specifically authorized simply because a general transaction has been authorized. And to engage in that distorted analysis, as Justice Kelly indicates in that dissent, is illogical.
So what's left of the word transaction?
Whenever a transaction is specifically authorized, then
I don't think that's your position. Your position
claim
is whenever a constituent part of a transaction is specifically authorized, not the whole thing. You just said something different, I think.
The focus is on what is alleged to be illegal. And if what is alleged to be illegal,
So to go back
irrespective of whether what was alleged to be illegal was a transaction
Brother Counsel
or
just said
conduct.
that the entire, it didn't require the entire transaction and all of its constituent parts to be approved for the exemption to apply. I understand that to be your position. If an entire transaction is going to be exempt, then the entire transaction and all of its constituent parts have to be approved by the regulatory body.
Well, if I disagree with that characterization, because that means, for example, that if the FDA approves only the safety and efficacy of a drug, that somehow they're approving all these unrelated constituent parts, such as pricing or exclusive supply arrangements
We're
with
stuck
Italian.
with the words of the statute, which is why I'm trying to plug your argument into the statute and understand what's left of the statute when I do that. I understand how we interpret the statute will have real-world consequences, and that some bad actors may get away with some bad conduct, but our job is to interpret the statute. And so I'm just trying to understand what the interpretation means for what's exempt under the statute as a transaction.
I've attempted to convey that that the focus should be on what is alleged to be unlawful. And if what is alleged to be unlawful has been specifically authorized, whether it's been specifically authorized in a transaction or specifically authorized in conduct, then the exemption would apply. But if it has not been specifically authorized, the exemption would not.
Counsel, I know we've heard a lot about Michigan and its rankings and how the Consumer Protection Act has been interpreted. Other states have similar acts. Do other states use the term transaction or conduct?
Several of them do, yes.
Okay. And
and in no state have we had the issues that have arisen under Smith versus Liss.
Do they have a
There's
different
one-
definition for transaction? I'm trying to understand, kind of to what Justice Viviano's asking, if you were to give us a definition of transaction, is it components of a transaction? It's all the components, and each one would have to be specifically authorized?
I think the focus is on what is alleged to be broken. How has
But that's not
the-
how we do it. We start with the statute and the words.
Right.
And the definition. So I'm asking you, what is the definition of transaction as you see it in the statute? Is it components? It's all the components that make up the transaction?
I think, no. I think a transaction typically is the sale of a good or service that has been specifically authorized. Now, in the case of insulin, what the FDA approves there is not presented to the FDA. Paul Novak has bought from Eli Lilly or from CVS a vial of insulin. The FDA has not approved that. What they have approved is, and so in that sense, they have not, quote unquote, specifically authorized the transaction between me and CVS. What they have approved is that the sale of insulin from CVS to me is recognized as being safe and effective. And this suit this investigation does not involve the safety and efficacy of the drug. That's not even being challenged. There's one last point I'd like to make, and you've been very generous of giving me an opportunity to address these things, and that is that several of the amici briefs conflate the issue of pervasive regulation, general pervasive regulated industry exemptions, and specific authorization exemptions. Those are two extremely different defenses and extremely different concepts in national consumer protection and antitrust jurisprudence. The Michigan legislature understood the difference. If you look at the antitrust statute, which I suggest should be read in pari materia with this one, they have two explicit exemptions.
Can you, I'm sorry, we're way over your time. Can you just wrap up your point? And
One for specific authorized conduct and one for pervasive regulated schemes. And I think the amici briefs conflate those two. If the legislature wanted to expressly include a pervasive regulatory scheme exemption into the Consumer Protection Act, they knew how to do it. They did it in the antitrust statute.
Thank you very much.
Thank you, Chief Justice Clement, and may it please the court, John O'Quinn on behalf of Eli Lilly. Almost 40 years ago in Keckle versus Allstate, the Court of Appeals unanimously adopted the approach to Section 4(1)A of the Consumer Protection Act that is at issue in this case. This court, in turn, endorsed that interpretation in Smith versus Globe Life. And in the intervening 25 years, the legislature has since amended the Consumer Protection Act some 23 different times, including revising Section 4's exemptions on 3 separate occasions. But in doing so, it readopted the language that Keckle and Smith had interpreted in Section 4.1a word for word, without suggesting that interpretation was wrong, while simultaneously changing other provisions that this court had interpreted in Smith. That unbroken chain is powerful evidence that Keckle and Smith were correct in their interpretation of Section 4.1a as exempting entire transactions. And the language of 4.1a is broader than the exemptions found in most other states' consumer protection laws, some of which exempt, quote, specific aspects or, quote, specific activity within transactions, such as Virginia and Maine. And regardless, this history demonstrates that this is a case where stare decisis is at its zenith. At the same time, the legislature currently has before it some 4 specific proposals that would remove the transaction exemption and change the language more along the lines of what the Attorney General asked this court to do by fiat. And with the Senate committee hearing testimony on this very issue just yesterday. This court should not short-circuit the ongoing legislative process, particularly in the context of a case that is not actually about consumer protection at all. It is just about overturning precedent. To be clear, the Attorney General has not identified a single patient that cannot access Lilly's insulin for less than $35 a month and has rebuffed requests by Lilly to engage on this so that if there were any gaps in Lilly's insulin affordability program, Lilly could fill them. The court should decline the Attorney General's invitation to overturn statutory precedent in this context and deny this application at this time. Now, Chief Justice Clement, you asked the question about, is transaction broader than conduct? And the answer is yes. And indeed, the Attorney General's brief itself acknowledges this at pages 2 and 3 of their reply brief, acknowledging that, quote, transactions are comprised of conduct, end quote, but at the same time that, quote, conduct can occur outside of transactions. And that means there's 2 different exemptions doing work. The transactional exemption, which broadly exempts all conduct in an authorized transaction, and then specific conduct that may or may not be part of a transaction at all. What we've heard today are 2 different and frankly inconsistent approaches that have been argued, and it seems that the Attorney General's brief at different times has argued different variants of these different approaches. One is to say that the challenge aspect, that the specific aspects of the transaction must be authorized. That's not the language in the statute, of course. And then the Attorney General's argument today seems to suggest that perhaps that if you have a specific particularized transaction that is authorized, that all aspects of it would be exempt. Again, the language of the statute doesn't refer to specific transactions. It doesn't refer to specific aspects of transactions. It refers to transactions. And that is what this court interpreted both in
Does it
Smith.
contemplate components of a transaction? Because
So-
that was another argument that has been made.
So whether you call it a component, an aspect, or part of a transaction, I think that this court, following the Court of Appeals decision in 1985 in Keckle, looks at whether or not, looks at the entirety of a transaction. If the transaction has been authorized, then the entire transaction is exempt, even if there are aspects or components of the transaction that were not themselves specifically authorized. And of course,
What if there are aspects or components of the transaction that were not specifically authorized but are illegal?
well, Chief Justice Clement, if there are other aspects that are illegal, then there are other laws that can address that. I mean, again, an exemption under the Michigan Consumer Protection Act doesn't exempt a transaction under the occupational code, the construction code, the vehicle code, tort law, the law of contracts, federal law, and indeed with respect to the antitrust examples under the MARA, what's at issue in those cases are entirely separate transactions. So if you have an agreement to price fix, that is not an authorized transaction. That is a separate transaction from the transaction of selling a particular drug or selling a particular product, whatever it may be. And likewise, if you have other agreements, brand generic agreements that were being referenced that are not at issue in this case. None of what was referenced by the amici, and frankly, most of what was referenced by the Attorney General is not at issue in this case. But those would be separate agreements, separate from the authorized transaction, and no one's saying that those could not be
How
challenged.
specific do you think the authorized transaction needs to be?
So I'll answer it this way, Chief Justice Clement. I mean, we're certainly not arguing. No one is arguing. No court has ever suggested that a mere business license, a mere license to do business in the state issued by the Secretary of State exempts any and all transactions. Our modest point, and I think the point that was recognized in Keckle and that was recognized subsequently in Smith and Liss, is that you simply need specific authorization to engage in a type of transaction. And that is the way that the case law has been applied in the intervening years. Whether that's a license to engage in specific kinds of transactions, or in this case, you have more than that. In addition to license to engage in selling medicine by the pharmacy board, you also have specific authorization by the FDA to sell particular products and indeed in particular doses, in particular packaging. And the statute as written exempts the entirety of these authorized transactions. And again, it would be very easy to write a different statute. Justice Welch, you would ask the question about how do other states approach this? The vast majority do not have a transactional exemption. The vast majority refer either to just conduct. So for example, Maine, Nevada, Colorado, Ohio refer to conduct and nothing else. Or an act or practice such as New York, Florida, Indiana, and Texas. And indeed, that is the type of language that is being contemplated in some of the bills that are currently pending, including House Bill 5201, Senate Bill 1021, both refer to, quote, a specific method, act, or practice, removing the transactional language altogether. And as I alluded to, even those states that have transactional exemptions are not all written the same way. Virginia, in Virginia statute section 59.1-199 says it has a transactional exemption, but then it says, quote, any aspect of a consumer transaction which is authorized under law. Well, that's what amici were arguing, but that is not what the Michigan Consumer Protection Act says. Similarly, Maine, in Maine statute Title V section 208, says the exception only applies, the transactional exception, only applies if, quote, the specific activity is authorized. And New Mexico, its statute, section 57-12-7, only exempts, quote, actions about which the regulatory body remains silent. So drawing a distinction.
So who can file a lawsuit under this? Who fits under the statute now? Because I mean, a lot of businesses have to get licenses and be regulated for their specific industry. So we've knocked out everybody who gets a specific type of license, correct?
Well, not quite, Justice Welch, and I think this was the issue in Diamond Mortgage, and it's how this court later understood Diamond Mortgage. I mean, Diamond itself said that they, quote, for this case, we need only decide that a real estate broker's license is not specific authority for all the conduct and transactions of the licensee's business, end quote. That's page 617 of Diamond Mortgage. And the point that Diamond Mortgage was making was the fact that you had a business there that was licensed to engage in real estate brokerage did not mean that its transactions involving mortgages, which it was not specifically authorized to engage in, were exempt. So merely because you are a regulated business does not mean that all of your transactions or all of your conduct are exempt. But those things for which you are specifically authorized to do, real estate brokerage in that case, they would be exempt. And so there's no inconsistency between Diamond Mortgage, and again, it said that was all that it needed to decide in that case. And there's also but there is an inconsistency between Diamond Mortgage and what's been argued today, especially from amici, because what essentially amici say is that, the test is that if what is alleged to be unlawful, that must be what is specifically authorized. But that's the same type and saying, well, it can't be that illegal conduct is specifically authorized. But that's exactly the kind of attaching of labels that Diamond Mortgage rejected at page, again, 617 of that opinion. And just 3 years later, a very Main Street unanimous Court of Appeals decided that did result in exemption for transactions that were specifically authorized. And it wasn't that the particular transaction had to be specifically authorized, but the transaction in general had been specifically authorized. And to the extent that there's any doubt about what the Michigan Consumer Protection Act meant in 1976, the world did not end then. As I made reference to in my opening statement, you have the legislature revisiting it in the year 2000, in 2003, and again in 2014. And literally, if you look at the face of the bills, the face of the bill recodifies Section 4(1)A exactly word for word as it existed, as it had been interpreted by this court in Smith. But at the same time, it added Section 4(3), it revised Section 4(2) in response to the Smith decision. So this is a case where, as Chief Justice McCormick put it in her separate statement in the North American Brokers case, 502 Michigan at 882, quote, "When the legislature reenacts a statute, we presume it did so with an understanding of this in court's interpretation of it." And that doctrine is certainly at its zenith here, as is the doctrine of stare decisis. I mean, Justice Kavanaugh, you made reference to the point that, stare decisis means sometimes that you have to uphold interpretations that you might disagree with. Respectfully, I think as Justice Kagan put it in Kimball versus Marvel, that's the only work stare decisis is ever doing, because if you agree with the interpretation, you don't need to rely on stare decisis.
It's not, it's not reliance on, it's just a decision that I or some of us might disagree with. It's a statutory language that the public shouldn't reasonably expect to be the case.
Well, I think with respect to statutory stare decisis, as again, the U.S. Supreme Court has recognized, it is certainly at its height in the context of statutory interpretation. The thoughtful dissent in the Page case in this court said, quote, the doctrine of stare decisis is particularly strong in matters of statutory interpretation, and that actually, as similarly the thoughtful dissent in the Robertson case, made the point that this is frankly important to the separation of powers and a respecting of the legislative role versus the judicial role, which again I would submit is at its absolute apex here, given the subsequent reenactment on 3 separate occasions since this court's decision in Smith. But if you are looking at this through the lens of stare decisis, then the questions are, is it practically workable? What are the reliance interests, and have there been a change in the law or the facts? And respectfully, I would submit that none of those in this case would warrant the overturning of precedent, which, as Chief Justice Kelly said in her separate opinion in Peterson, you really need a compelling justification for overruling precedent, and that's particularly true in the statutory context. Here, it is certainly practically
Counsel,
workable.
I have a question, and you're doing an excellent job, but I guess my question goes to this fact. If we were to overturn Smith and Liss, what are your primary concerns? What is it that you think is so problematic about the overturning of these cases?
So, Justice Bernstein, thank you for the question. I appreciate it, and I would say there's several things. One is the implications of overturning 25 and indeed arguably 40 years worth of precedent and the institutional concerns that creates. But second, I think that all of the factors that weigh in favor of application of stare decisis also show what the perils would be to the contrary. One is practical workability, and one of the concerns that this court recognized in Fiesel was whether, in that case, the existing precedent invited arbitrary and discriminatory enforcement. And that is a concern that we have, that if this precedent is overturned, that it invites just that it invites regulation through litigation in areas that are intensely, comprehensively regulated. I mean, I'd point you to the Eighth Circuit's decision in the Enry Canadian import case, which makes it clear that the Food, Drug, and Cosmetic Act, quote, comprehensively regulates the manufacture, importation, and sale of prescription drugs. The approval process is specific to each manufacturer and each product. And you also worry about the unintended consequences of regulation through litigation that happens on top of a highly regulated regime where there is specific authorization. As the Attorney General said in her brief at page 41, the precedent is admittedly easy to apply, end quote, and so there's no unworkability. I see that my time has expired. If the court has further questions, I'm happy to answer them, but otherwise, In closing, we respectfully submit this is the wrong case and the wrong vehicle at the wrong time for revisiting precedent, and ask that the court deny the application.
Thank you.
Thank you, Chief Justice Clement.
Justice Welch, in answering your question, Brother Counsel said that essentially you can sue a prescription drug manufacturer as long as a lawsuit has nothing to do with prescription drugs. You can sue a builder as long as a lawsuit has nothing to do with building anything. In Dix, back in 1987, this court said that the Consumer Protection Act provides an enlarged remedy to consumers. The Smith court contradicted that by taking a broad law and flipping the paradigm, so now we have a broad exemption to a law designed for consumer protection.
Mr. Fowler, can you address the argument made by opposing counsel that the legislature specifically reenacted this provision multiple times? I mean, normally we don't take really much from legislative silence, right, that they haven't amended it, but what about the argument they in fact reenacted this provision?
It is of no moment in the analysis. In Hawkins, this court rejected the reenactment doctrine. In Rauch World, this court emphasized that it doesn't look to subsequent legislative history. The United States Supreme Court doesn't look to subsequent legislative history. If we look at what was going on in the intervening years when the legislature was tinkering with the Section 4, it was always with regard to this insurance aspect. If you look at the legislative history that Lilly and Amicus attach, the legislative documents make clear they don't speak to legislative intent, and it's always because the insurance industry wants to do this. If the legislature were focusing on Smith and Liss and what was going on in those decisions, it would have had to have looked at subsection 2 more broadly, rather than restricting its view to thinking, oh, something was wrong in Smith just because of the insurance industry. Subsection 2 speaks to many industries.
Okay, thank you.
Thank you for your time this morning, Court. We ask that the Smith and Liss decisions be overruled.
Thank you all. Very, very helpful arguments. The case will be submitted.